Okay, hi everyone. I'm Leanne Prendergast. I'm the chair of the Florida network of IWIRC. If you don't know, that's the International Women's Insolvency and Restructuring Confederation. We did invite members of several voluntary bar organizations to join us for the panel today. I hope that you were able to join. And if you're interested in IWIRC, be sure to go to iwork.com. Or email me and or another member and ask about IWIRC. It's a fantastic organization. I hope you'll check us out. We are recording this, so your failure to disconnect at this time is your permission for this recording. Also want to just a couple other real quick housekeeping things. We have a PowerPoint. I think it's a fantastic resource. We're not going to page through it today, so we're not going to do that, but we will send it out. We'll email it out afterwards. Some of our panelists were participants in the ABI insolvency, Caribbean insolvency seminar recently, and we used some materials from that and some of our own and put this together, and just wanted to be sure to thank the ABI for allowing us to do that. We do have CLE numbers for Puerto Rico and Florida, which we will share later. And the panelists' bios are in the materials, at the end of the PowerPoint that we're going to email out. So I won't take the time to go through those this morning. Just do quick intros and get going. We want to be respectful of everybody's time and be done in 1 hour. And we have a lot to talk about. So our panelists include Sonia Colon of Ferrololi. I cannot say it, Sonia. I'm sorry. Will you say it for us?
Ferraioli.
Thank you. Thank you. Carol Fox of B. Riley Advisory Services and Jill Kelso of the U.S. Trustee's Office. Thank you, everybody. And let's get going. We've got lots to talk about. First, Jill, can you give us some statistics on Subchapter 5 filings in Florida?
Sure. Good afternoon. I'd be happy to do that, Leanne. Thank you all for attending our virtual presentation. It's certainly my privilege to speaking with such an esteemed group of ladies through the IWIRC Florida network. We've certainly learned a lot over the last year about Subchapter 5 cases and the SBRA. And one thing I have to say is that my comments are not official comments or position statements on behalf of the United States Trustee Program. With respect to the filing statistics throughout Florida, I want to thank Kathy Dietz and Joe Falzone who helped me compile this information. But we are pumping with these cases. In the Middle District of Florida, the total cases that have been filed under Subchapter 5 as of April 22nd were 165 cases. 15 of those were in Fort Myers, 21 in Jacksonville, 63 in Orlando, and 66 in Tampa. In the Middle District of Florida, we have 10 Subchapter 5 trustees in the pool available for appointment, 3 of whom are out of the Tampa office and 7 of whom cover Orlando and Jacksonville cases. In the Northern District of Florida, there have been a total of 13 Subchapter 5 cases filed since inception of the SBRA, and there are 2 Subchapter 5 trustees in the pool there, one of whom is also in the pool in the Middle District, and that's Jason Burgess. In the Southern District of Florida, there have been 90 Subchapter 5 cases filed since February of last year, 41 in Fort Lauderdale, 29 in Miami, and 20 in West Palm Beach, and there are 6 Subchapter 5 trustees in the pool available to handle or for appointment to handle those cases. And I believe Sonia has the filing numbers for Puerto Rico.
Hi, thank you, Jill. It's a pleasure to be here as well. For Puerto Rico, we have been active, but not as active as in Florida. Since February 2020, there have been 50 cases filed under Chapter 11 in the District of Puerto Rico. Of those 50 cases, 17 of them are Subchapter 5. As of February, when the Caribbean Insolvency Symposium was held by the ABI, there were only 9. So it's slowly picking up. Out of those 17 Subchapter 5s, 2 of those have been dismissed. There were single asset real estate, which we will discuss later. 3 cases have been confirmed, and 13 cases are pending confirmation. An overview of those cases shows a variety of industries. We detected cases in the travel industry. We detected cases in the medical industry, vet clinics, individual cases, stores, but especially in tourism, there's, I think, like 3 cases related to that industry. So it's slowly picking up. We'll be commenting on these cases as we go along, and I hope you enjoy it.
Thank you. So let's start with eligibility. Jill, will you start us out on that?
Sure. There are multiple components of eligibility that we wanted to discuss today. One of those deals with when you have multiple affiliated debtors. You have to aggregate the non-contingent unliquidated debts of all affiliated debtors, and the total amount of that aggregated debt must be less than the limit. There is a decision. It's in Ray 305 Petroleum, in which the court determined that you even aggregate debt across Subchapter 5 debtors and Chapter 11 debtors who are not in they're just regular Chapter 11 debtors. So if it's a debtor, you look at the debt and it must be aggregated, and the aggregated amount must be under the debt limit, which is currently $7.5 million up through March of next year. There's another little wrinkle to this, is that I had 3 hotel cases in Jacksonville. One of them was properly venued in Jacksonville, the first case, and then they used the affiliated debtor status to file, or venue status to file for a hotel located in Springfield, Illinois and Wichita, Kansas. So we obviously, because they're affiliated, had to look at the debt in the aggregate, which exceeded the limitation. But it was interesting because they were using the affiliate venue provision to file the Kansas and Illinois hotel cases in Jacksonville. And so, of course, obviously, it would trigger the necessary analysis when you look at the debt in the aggregate. So that's something that, may or may not be front and center, particularly if you have a debtor, if you have multiple debtors that are in sub 5 that are affiliated with a debtor that's not in sub 5. If the debtor that's not in sub 5 is not in sub 5 because it exceeds the debt limit, it will make the other subchapter 5 debtors ineligible. So it's an interesting wrinkle there.
Commenting in that case, the one that Jill commented is 305 Petroleum. One of those cases was dismissed because it was a single asset real estate. Nonetheless, the other affiliates had to count the debt on that one. One anomaly case that Carol mentioned some months ago for another seminar, and I have been following, is the Rico's case. And in that case, it's very interesting because Rico's is the office spaces, and a lot of the affiliates started filing bankruptcies as well as Subchapter 5. And I was asking myself, how come Rico's, such a huge corporation, be filing Subchapter 5s? Well, at one point, they redesignated, because as more Rico's affiliates will join, they'll soon surpass the eligibility limits. So in that case, it's one that was very important in terms of affiliates and how they went back to a Chapter 11 instead of the Subchapter 5.
That is interesting. And there's another wrinkle too with SEC traded companies. Jill, can you tell us about that?
Yes, this case I had actually came out of the Southern District of Florida, and it's a case in which is frankly, it's on appeal, and I participated in preparing the brief on appeal. It really wasn't necessarily an eligibility issue on appeal. It was more a corporate authority to file issue. But what happened was, as we approached the confirmation hearing, the name of it is 5 bars. As we approached the confirmation hearing, the SEC actually filed an objection to confirmation, stating that because the debtor is one that is required to abide by the reporting requirements under Section 13 or 15D of the Securities and Exchange Act, that excludes them from eligibility under the definition to be a small business debtor. And indeed, that is an exclusion. Ultimately, that case was converted, and so to Chapter 7. So it really didn't play out. But I know that sort of may be a really good segue into the issue as to whether and at what point in the case it's appropriate to raise issues of eligibility. Obviously, Sonia, if you want to mention the rule that deals with the time frame within which objections to eligibility are filed.
Yeah, the bankruptcy rules give 30 days from the Section 341 creditors meeting, or if later, 30 days from the filing of an amended designation to object to Subchapter V designation. And that's Rule 1020B. So in these cases, both debtors and creditors have to move extremely fast.
And then actually, I have another case that we're working on right now where an objection to eligibility was raised in the context of an objection to confirmation, or actually it was in the motion to dismiss that the court was considering whether to set over to confirmation. And so the question became, do we just hear, the motion to dismiss, including the eligibility piece at confirmation? And frankly, the concern was that, well, if the debtor is not eligible to be a Subchapter V debtor, then it's going to dictate whether they're able to confirm a plan under the provisions of the SBRA, or whether they need to instead revert back to solely confirming under 1129. And so that case is currently pending in front of Judge Vaughn. And what she did was she basically bifurcated the issue and had a trial just this past Wednesday as to whether that particular debtor is eligible. And the question there is whether the debtor is single asset real estate, such that it would also meet the exclusion in the definition to proceed under Subchapter V. So timing of that issue is interesting when it's sort of being vetted at the same time with other issues that ultimately impact confirmation.
That is interesting. Another interesting area where there's been a recent kind of flurry of case law is the requirement that the debtor be engaged in business. Carol, you have an interesting case for us on that.
Right. Thank you, Leanne. So for those who do not know me, I am a Subchapter V trustee in addition to a senior managing director at B. Riley. So I was appointed when the act became law, and since then I've had a dozen cases. And so just by way of background, I had a case where I was almost 100% sure the debtor was not operating. So this has set my radar on this issue, and I've been following it very closely. But an interesting opinion was published recently by the ABI on April 21st, and it was an opinion by Judge McNamara in Denver, who basically said, although the debtor must be currently engaged in business at the time of filing, he said that a fast food worker flipping hamburgers would qualify if half the debt arose from the, quote, commercial or business activities of the debtor. In other words, in the opinion of Judge McNamara, a debtor's debt must arise from business, but the debtor isn't required to be engaged in that business, which is interesting. And this opinion is actually consistent with another opinion in a case called Wright.
Hello.
But then there's divergent opinions too, which Jill will discuss.
So this is Andrea.
Thank you, Carol. Yes, there is a couple of decisions. One is In re Thurman, and that's out of the Western District of Missouri, as well as In re Johnson out of the Northern District of Texas, where the court considered this issue as to whether the debtor was engaged in commercial or business activities. And in the Thurman case, the court indicated that engaged in means to be actively and currently involved. And the court ultimately determined that the debtors were not so engaged because they had ceased operations of their businesses pre-petition and sold those businesses. So basically, the debtors' prior businesses were essentially shell companies, and that keeping the empty shell of a former business entity open just with the Secretary of State's office does not render them to be engaged in business. That was the Thurman decision. And then in Johnson, the court also held that the engagement in business activities needs to be some sort of current engagement, and that a person who at some point in the past had such involvement would not be sufficient.
So I do
That
want
makes
to point
sense.
out that, sorry, Leanne, that the McNamara case and the debtor's name I cannot pronounce. I'll just commend you to the case law on that. But in this case, the debtor did have almost $7.5 million of unsecured debt. And the principal of the debtor or the debtor's representative contended that his business was winding down the affairs of the debtors. And the judge and actually, I think the U.S. trustee also agreed with that.
It's funny when you think about the purpose of this section of the code. It's to help an active business quickly reorganize, and they're getting, special powers that others don't get. That seems odd to me that you could use it for someone that doesn't have that same urgency to reorganize.
I think so too, especially since the Act stresses a plan of reorganization over 3 or 5 years, and this would be a plan of liquidation.
Right.
On a good day. So.
Right. I'm trying not to continue using the word interesting, but intriguing.
It's Leanne, when you read the cases that the judges that have ruled and making this temporal analysis, they go back to the congressional intent, and it's twofold: to improve the ability of small business to reorganize and to remain in business. So in that analysis, they say, those that say, oh, it doesn't require that they be in operations right now. But if you go, what was the purpose of Subchapter 5? You have to, I cannot issue an opinion, but you kind of agree that it has to be in operations.
They should have just asked us, right? we could have told them.
And I will comment that the courts are very debtor friendly. I had a debtor who said, but all I need is a white knight. I was like, hey, me too. I've got lots of debt. Let them ride in. But the judge, and he did have very loosely constructed LOIs, and the judge let him go for quite some time. So, it is just is the way it is, I guess. So.
Right. What about a nonprofit? Carol, didn't you have or Jill, did you have a case with that?
Well, there was a case that in which that issue arose here in front of Judge Sheneman, and one of the constraints in the definition is that not less than 50% of the debt must have arisen from the commercial or business activities of the debtor. And in this case, it's called Ellingsworth Residential Community Association. It was basically an HOA. And the creditor argued that because there was no profit motive in the HOA's operations, that essentially rendered them ineligible under the definition for Subchapter 5. And Judge Sheneman ultimately overruled the creditor's objection, concluding that the debtor engages in commercial or business activity and otherwise fits the definition under section 101(51)(d)(a), without regard to whether they have a profit motive. There were business operations, and so that was sufficient to qualify.
Carol, didn't you have a case as well?
And so I have an active case right now that's also an HOA. The issue did not arise, but my case is called the Palms NL, and it's similar. Their debts arose from water damage that was uninsured. So that's the primary causation of the filing. And then, as I mentioned in our warm up, it is also suffering from what I termed heaps of deferred maintenance due to the fact that the unit owner assessments were so low for so many years. They recently doubled them, and they're gasping for air, but it needs to be cleaned up. So anyways.
That'll be a challenge.
Yes, it will.
So we've touched on single asset real estate a couple of times, but what's the deal? Is that an impairment to eligibility? Jill, you got a case on that, right?
Yes, absolutely. That is one of the exclusions for eligibility under the definition. So it excludes a person whose primary activity is the business of owning single asset real estate. And actually, we have a decision from Judge Gentleman as well, a recent decision it was issued on April 20th, where she determined that the owner and operator of a 79-room Econo Lodge Hotel is not single asset real estate and is thus eligible to proceed under Subchapter V. Here, the secured creditor and holder of both an unsecured and a secured claim objected to eligibility. And the court determined that the hotel provides additional value or activities beyond property management that would remove it from the single asset real estate definition, including having 15 employees, cleaning rooms daily, serving breakfast, maintaining a swimming pool and providing laundry, internet and phone services. So Judge Gentleman determined that these additional operations and services constituted something more than mere operating the real property and activities incidental to that operation. So she permitted that case to remain in Subchapter V. And I note that I had an evidentiary hearing just this week in front of Judge Vaughn, where this is the threshold issue before we get to confirmation as to eligibility. And in that case, it's the debtor owns two parcels of real estate. There's a non-debtor parcel in between the two over which there's an easement connecting both parcels of real estate. On one of those parcels of real estate, it's a vacant lot, and the other one, there's a commercial facility at which the debtor has one tenant. And so Judge Vaughn will be ruling within, I'm assuming, the next month or two related to whether that case is single asset real estate, such that it would be excluded under as a debtor under the definition for Subchapter V. So those issues are playing out, and I know that Sonia has seen that there in Puerto Rico.
In Puerto Rico, we have two cases already in single asset real estate. One of them was La Merced Limited Partnership. That has a convoluted story beforehand, before it redesignated to Subchapter V, but the secured creditor and the debtor had reached an agreement that they have to pay by a certain date. And if they didn't pay by January 30th, 2020, the property had to be sold in a 363 sale. Well, the debtor defaulted. It sought to change the terms of the stipulation under this theory in civil in our civil law, which is rebus sic stantibus, and the judge said no. So the debtor comes along and he files a redesignation for subchapter 5. And immediately the U.S. trustee and the secure creditor come across and they object, sustaining that single asset real estate debtors are ineligible for subchapter 5. This debtor, when they filed the petition originally, this case is from 2018, they had checked the box for salary. So when they are in 2020 and they seek to convert in the middle of this controversy with the secure creditor, well, they thought that they could change and then the problem will be resolved. Well, the U.S. trustee moved very quickly in that sense. The case went on appeal, but then they dismissed it. The debtors dismissed the same. We have another similar case of similar outcome, which is Jaylene Clara Gomez Mojica. In that case also, there was a single asset. The debtor did not qualify. The creditors came along and they said it was because it was a single asset real estate. We expect these cases to keep flowing in Puerto Rico, to keep some cases until they end. What is really a single asset real estate? It's a very, in that gentleman case, it's source of a lot of debate when you go through all the jurisdictions. So we may be seeing more cases in this regard.
Okay. What about individual subchapter 5 cases? Can we touch on some issues there, exemptions, liquidity, disposable income?
Sure, I'd be happy to talk about those. The individual subchapter 5 cases, one of the big questions is how do you determine disposable income? And the code, the SBRA has a definition for that. And it's income, it's in section 1191D, as in D as in dog. Disposable income is income received by debtor and not reasonably necessary for the maintenance or support of debtor and debtor's dependents, a domestic support obligation, or for expenditures necessary for the continuation, preservation, or operation of the debtor's business. And so in an individual case, the question is, do you look back and perform sort of what may be a means test analysis for purposes of a 707B motion? Do you look at what a Chapter 13 trustee and parties in interest may be considering for purposes of confirming a Chapter 13 plan? And I note that certainly in an individual case, a debtor's claim of exemptions is relevant in determining liquidity, which is sort of a Chapter 13 concept as well. So for example, in an individual case, if the debtor is claiming certain assets to be exempt, but they haven't substantiated those assets meet the exemption requirements, then perhaps those particular assets need to be encompassed within the liquidity analysis. So there are some unique components when looking at the subchapter 5 cases of individuals. And I know one other component of it that is rather unique and is something that we're scheduled to litigate next Wednesday in front of Judge Vaughn is how does removal work if the debtor is an individual? I note that the bankruptcy court for the District of New Mexico entered an order removing individual debtors in possession. And that's something that we're considering in one of my cases here. But the question is, the individual debtors, they need to buy groceries, they need to put gas in their car. And in the subchapter 5 trustee, in a case in which a debtor is removed, takes on the additional responsibilities that are identified in section 1183B5. And, I don't think any of the subchapter 5 trustees have the time, the wherewithal, or any interest in, accompanying the debtors to the grocery store or what have you. So these concepts and the mechanics of removal in individual cases become you really have to look at how that's going to work. And we're considering putting in controls in place so that the debtor can operate, use a debit card to do these things, but do so according to a court-approved budget so that there's some added transparency, but that the procedures don't make it such that the debtor can't, do basic things, attendant to his or her living situation without the trustee being there at every step of the way. So it's an interesting concept in an individual case. And I also would just say that I have a corporate case, speaking of removal, in which the debtor was removed. The debtor had a golf course, and creditors in the city came in and sought removal of the debtor. The court granted removal, and ultimately there was a very good result in that case, in that the Subchapter 5 trustee was able to sell the asset and pay everybody in full, and ultimately there will be a return of money back to the equity owners. But one interesting wrinkle came up, and that is the code provides that under Subchapter 5, the debtor has the exclusive right to file a plan, and that carries through even to cases in which the debtor in possession has been removed. So it presents an interesting, here we go again with the word interesting, but it presents an interesting posture, because you have a situation where the Subchapter 5 trustee is handling and overseeing and doing much more of the operations side, but but cannot file a plan. It's only the debtor that can do it. So, and in that case, the golf course case, we had a great result. The debtor's attorney filed a plan that basically everybody was unimpaired and will return money back to the debtor. So honestly, if everyone's unimpaired, it may not even need to be solicited. But I don't know that that's going to be a result that is something that we see commonly, but it did work out. But it's something that parties in interest need to consider once the debtor is removed, how the case will get across the finish line.
What are I'm sorry, go ahead, Carol.
I had my powers expanded as a Subchapter 5 trustee, and we preface this in our warm up too with be careful what you wish for. And I lasted 5 days, and I'll say, and there wasn't as good of a result as the case that Jill referenced. The case actually converted, and I think the Chapter 7 trustee ended up abandoning the assets. What had happened was, this was the same case I referenced earlier, where the debtor said, but all I need is a white knight. And so it looked like we had a buyer on the hook for a 363 sale and to run a quick process, and everybody would be made whole, and the world would be right again. And that quickly evaporated when we learned that, number one, the debtor was not operating. And this was actually very serious, because this was a healthcare organization, and we're going to get into this a little bit later, but what they were running a Medicare Advantage plan. They were not answering their phone. There were patient complaints, which I found out about once I started operating the business, because they called me. And furthermore, there was no insurance, which just pretty much ended the case right there. So it's hard, I think, in these cases, because they are on such a short leash, to make a quick decision and evaluate everything that needs to be evaluated. Is there insurance in plan? Is the debtor viable? And instead, these cases tend to get the Subchapter 5 trustee powers seem to get expanded at a hearing. Like, it just happens, there, and without a whole lot of discussion ahead of time. And the debtor is removed. In my case, the debtor's attorney had no interest in crafting a plan. So that would have been on me as well. So.
Like the dog that caught the car. What now? What are the grounds to remove a debtor in possession? Is it the same under 1185 as in other sections of the code?
So, Leanne, section 1185 articulates grounds, and it just says the court shall order that the debtor shall not be a debtor in possession for cause, including fraud, dishonesty, incompetence, or gross mismanagement of the affairs of the debtor, either before or after commencement of the case, or for failure to perform obligations of the debtor under a plan confirmed under subchapter 5. So if you look at section 1112, which is the provision that governs conversion or dismissal, 1112B also provides that the court shall, on request of a party in interest, convert a case under chapter 11, or dismiss a case, whichever is in the best interests of creditors and the estate for cause. And then there's in 1112B4, there's specific delineated areas of cause, but then there's also case law cause, and those lists are not necessarily definitive. There could be other examples of cause that are not specifically set forth there because the list is preceded by the word includes. There's also a remedy in 1112 that says that if the court shall convert for cause or dismiss for cause unless it determines that the appointment under 1104A of a trustee or examiner is in the best interests of creditors and the estate. And then when you go to 1104, now that's applicable solely to non-subchapter 5 cases, but when you go to 1104, it also talks about cause for the appointment of a chapter 11 trustee, including fraud, dishonesty, incompetence, or gross mismanagement, which is a very similar standard to that which is set forth in 1185. And then under 1104E, it requires the United States trustee to move for the appointment of a trustee if there are reasonable grounds to suspect that current members of the governing body of the debtor basically participated in actual fraud, dishonesty, or criminal conduct in the management of the debtor or the debtor's public financial reporting. So this is a long-winded answer, but I think these provisions provide that cause would be somewhat similar, at least multiple components or areas of conduct could constitute cause under 1185, 1112, and 1104. And it's relevant because I think, as you know, perhaps as a practice pointer, folks who are seeking these types of remedies in subchapter 5 cases may wish to consider what the reaction will be from the debtor upon once such a motion is filed. So, for example, in one of my subchapter 5 cases, the subchapter 5 trustee and I filed motions to convert the case. We were set for trial, which actually I just finished right before I logged on to this presentation. And while we were set for trial, the debtor filed an amended petition to deselect that it wished to proceed under subchapter 5, that it instead wanted to proceed under regular chapter 11. Well, of course, if we're under a regular chapter 11, then the concern was that whatever the cause existed to seek conversion would then seek to would exist to support the appointment of a trustee under section 1104. So sometimes these things are fluid. And what I ended up having to do, I filed an objection to the amended petition. And I also filed a supplemental motion to convert, arguing that should the court allow the amended petition to stand, then the U.S. trustee would be seeking the appointment of a trustee under section 1104. So that's a very long-winded answer to say that these remedies are related and they may play out depending on how the facts evolve in your cases.
So that's good. And, 1185 might be new, but it sounds like we can certainly turn to case law under 1112 and 1104 for, interpretations of what does this mean? What is cause for removal of the debtor in possession?
I think that's right.
Well, moving on, I think we're ready for practice pointers. And I wanted to be sure to remember, Jill, you had provided us, and we'll circulate this with the materials, with a standard order that was developed by the Middle District of Florida for Subchapter 5 cases. Can you just briefly talk about that?
Sure. So the court in the Middle District of Florida, I think perhaps is on the cutting edge with their first day order that gets entered as a matter of course now in all Subchapter 5 cases. And it has some great provisions in there. And I think it best just maybe to highlight maybe two of these in the interest of time. But one of the provisions that the court orders from the outset is that communication with Subchapter 5 trustee is the title, and it says debtor's counsel, or if the debtor is self-represented, the debtor shall contact the Subchapter 5 trustee within 5 days of the order to discuss the trustee's facilitation of the development of a consensual plan of reorganization. The debtor is expected to communicate regularly and share information with the Subchapter 5 trustee as is appropriate under the facts and circumstances of the case. So I think I would say that's the first practice pointer that comes out of the directives in this order, which is essentially to facilitate the Subchapter 5 trustees' efforts in reaching a consensus so that a plan can be confirmed consensually. I mean, that is the goal. And so if the debtor is not cooperating and fails to utilize the efforts and the resources of the Subchapter 5 trustee, it sort of cuts against and makes it a bit more difficult for the Subchapter 5 trustee to work their magic in these cases. And I'm sure Carol has some comments on that. And I just wanted to mention one other piece, one other provision of this order. It provides for interim trustee compensation. And that's obviously important to the Subchapter 5 trustees who certainly, don't want to go unpaid for their efforts. And it requires that within 30 days of the petition date and continuing monthly thereafter, the debtor shall remit to the trustee interim compensation in the amount of $1,000. So that amount then is subject to adjustment by the court if somebody asks for that, and ultimate approval once the Subchapter 5 trustee files a fee application under Section 330. This provision also requires for trustees' interim compensation to be included in any proposed cash collateral budget. So this is going a long way in making sure that the Subchapter 5 trustees are being compensated for their efforts. And sometimes these cases, they come in and there's really tight margins, and it's not always certain that they're going to get across the finish line. And this at least goes a long way to make sure that the Subchapter 5 trustees will receive compensation for their efforts.
So to Jill's point, yes, I have something to say. I have something to say about virtually everything though. I had 3 cases that one was dismissed. No, 2 were dismissed. 1 was converted. I was paid on one of the 3. But to her first point regarding communication between debtors counsel and the subchapter 5 trustee. I like the fact that that's out there and debtors counsel is directed to communicate with the subchapter 5 trustee. I take a different approach. I reach out within probably 24 hours after I've been appointed and, you know, just get the, usually the case management summary is filed by that point, but even if it is, I still just go over it with them and find out, you know, where the bodies are buried, if any, and where the hair on the case is. But then secondly, I made a point recently in a meeting that we had in the Southern District where it appears that sometimes debtors go to subchapter 5 land, camp out there, and then after 90 days, you know, they can't cobble together a plan for whatever reason, no harm, no foul, and off they go. And since they're not on the hook for U.S. trustee fees, I mean, there's like in their minds, literally the only amount that they're out of pocket is for their bankruptcy counsel, and that's it. So I like the fact that this is at least set forth without argument in an order. I fight for all of those things. When a case is converted, my very first case was converted, and I said that's great, but you need to pay my fees, no problem with that. And then recently we had a cash collateral hearing, and I asked the secured lender to have to prime my fees if the case was converted. And again, there was no issue, but these are issues that I'm having to raise on my own. And just so everybody on this call is aware, I'm not an attorney, so I'm doing these things on my own, and it's probably just because it's after a year of experience that I know that these issues arise, and probably after 30 years of practicing that I also know that they arise. But it's just really refreshing that the Middle District has taken this approach so that the time is used more productively than discussing issues like this.
Well, I never even thought about that, Carol. You, I guess you don't run out and hire an attorney to kind of like protect your interest with getting your fee paid. I don't even know if you could really. So that's good that you're on top of that. And like, didn't you have a tip for us on the cash collateral order, I think?
Well, yes. And so that's what I, while most secured lenders won't allow for the subchapter 5 trustees, even the escrow of the subchapter 5 trustee fees to be included in the cash collateral budget, they will allow for them to be paid at confirmation, obviously. And so what I do, since they're very hesitant to allow that into the 13-week cash flow, is I have them put in the cash collateral order. If the case is converted, my fees come first. And there seems to be I haven't had any issue with that either. So the only spot where I really feel like the fees are totally at risk is in the case of conversion. If there are no assets to pay fees, which is a risk in any case, really.
So you really have to be proactive, paying attention and making sure, even if you can't get it into a cash collateral order, you're kind of keeping it in people's mind, like that might not be a line item in the budget, but it is part, one of the things that has to be factored in.
Right. It's a cost of running the case, and it's a cost of getting them paid too. So
Mhm.
I
Yeah.
was preparing for the seminar. I found this case out of California, Slide Belts Inc. And it says a potential solution, this is what I found, to these problems is to request that the court condition dismissal on allowance and payment of the trustee's compensation. In that case in particular, the debtor, he wanted to dismiss just to get a PPP loan and then refile. But it was said that it was a condition to dismissal that it had to pay those trustees' fees. I found that case very interesting, and again, the interesting part. And law is developing, but it's a potential solution to this.
That's another great tip. It's another opportunity.
I just wanted to point out to the audience that there is a section in the materials regarding PPP loans and the ability of a debtor to apply for a PPP loan as a debtor in possession. And that's still, while it's law, it's still up to the discretion of the SBA as to whether a debtor in possession can apply for a PPP loan. So I just wanted to commend you to the materials, because that is discussed, and there is some case law included on that topic.
Carol, thank you. I remember when the legislation came out, I was a little unclear just from the summary I read. I can't say I went and read the legislation, but I did read a summary. And does the SBA director have to approve it on a case-by-case basis? Okay.
I believe that's the case.
I'm sorry to interrupt, but the administrator of the SBA has to give some writing to the director of the United States Trustee Program as a precondition to allowing those PPP loans, to be issued while an entity or person is in bankruptcy. And to my knowledge, that's not yet happened.
Okay, that's the thing I was thinking of, and that's kind of a one-time thing, and it would apply to all cases.
That's my understanding. Okay. I have to disclaim, because I haven't gone back and looked at that super closely recently, but that's my understanding.
Yeah. I'm curious, sir. I'm so curious to see if that happens, since the SBA fought, so many cases saying you can't be a debtor and get a PPP loan. For the administrator to have the discretion whether or not to approve it, it seems a little odd to me. But
and there's actually 11th Circuit case on that. I don't have the name or the citation with me right this second, but I can certainly provide it if anybody's interested.
It's in the materials, Jill. I think the case is called Gateway.
Thank you.
Mm-hmm. Sonia, you had a really good tip for us, kind of right at the beginning of the case, things that you need to think about.
This case is really from, we have been meeting Carol, Jill, and Leanne all along. And from everything that I have reviewed, these are not the cases really to learn about Subchapter 5 or how the Chapter 11 process works. These cases work, they play out very, very fast. You have 180 days you can obtain to file the plan. The debtor can obtain extensions, 90 days, provided it can show that the need for the extension is attributable to circumstances that he's not to be held accountable. These cases really, the ones that work well are those that the ones that are essentially pre-packs. You know who the folks are, you know who the parties are, and you are on the get-go since day one. The same for creditors. Creditors have to move very, very fast in terms they have limited time for objecting to the designation. Creditors think that in these cases they have lost a lot of their rights. Not necessarily. A lot of the issues remain in place, like the best interests of creditors, 1111P, adequate protection, curing defaults, how they are cured. All of this remains in place, but both parties have to come in since day one and act very fast just to make them successful. Just bear in mind always the CARES Act and the Consolidated Appropriations Act. That one remains in place till December 27, 2022, made certain changes and new provisions that affect Subchapter 5. So always have them in mind. Nonetheless, in these cases, my advice is just since day one, be very on top of it and educate yourself beforehand on how to handle these cases.
I remember you said you should have an exit strategy going in. And I've always said that too. Like Chapter 11 is really easy to get into, right? You fill a form out, assign a form. It is not easy to get out of, and you really need an exit strategy before you ever file the case. And I think your point, Sonia, was well taken, and it's even more so in a Subchapter 5 where you're moving so quickly. You've got to have an exit strategy when you file the case. You can't just, file it and hope for your white knight, right? In order
it's
to
like hotel in California. You can go in, but it's not that out of there.
Carol, you had
advised that Subchapter 5s are not for, and Sonia, you may have said this when I was dealing with my dog, but it's not a Subchapter 5. I think people think maybe attorneys construe this as, oh, it's a beginning course in bankruptcy in Chapter 11. I'll just try my first Chapter 11 here and see how it floats. And I have gone as far as teaching monthly operating reports to debtors' attorneys, and so it isn't a good, and one could not get it no matter how many times the cutoff eluded them, no matter how many times I explained it. But it's not a good place to get your feet wet, and you definitely need to hit the ground running in order to make the case successful. My most successful cases are the ones where the attorney tells me on day one, it's this creditor, it's this water damage, it's this, it's that, and these are the issues that I need to deal with. I've already reached out to them and almost struck an agreement with them.
That's great. And then one other thing I wanted to quickly touch on, I think it's very intriguing, was the patient ombudsman issue that you raised, Carol. Can you give that a minute?
Sure. So I see the patient care ombudsman from both sides because I am a Chapter 11 trustee with a case that has a patient care ombudsman appointed. So I have probably 75% of my larger cases are healthcare cases, so I'm very familiar with them. But this issue comes up every time in a healthcare case, either a medical practice or an ambulatory surgery center. If the case is healthcare related and the debtor has checked that box, then the issue of a PCO, as they call it, needs to be vetted. I had a case where there was not a PCO appointed, and maybe the case did require one because as it turned out, the debtor was not seeing the patients. It was a Medicare Advantage plan, and the debtor was not performing their responsibilities under the Medicare Advantage agreement. I'm kind of on the fence on this one. I really am of the strong belief and that if a case is so complex and the debtor's healthcare operations are so complex that they require a PCO, they should really be a regular Chapter 11 and not a Subchapter 5. I mean, that's just my opinion, and it comes from 30 years of healthcare experience, but and not so much as a Subchapter 5 trustee, but just in understanding the role of a patient care ombudsman in a Chapter 11.
Thank you for sharing that perspective, Carol. I just wanted to mention for our attendees that it's section 333 of the code that deals with the appointment of a patient care ombudsman. And it basically says that if the debtor in a case under Chapter 7, 9, or 11 is a healthcare business, the court shall order, not later than 30 days after the commencement of the case, appointment of an ombudsman to monitor the quality of patient care and to represent the interests of patients of the healthcare business, unless the court finds that such appointment is not necessary for protection of patient care or patients under the facts of the case. So that's an interesting, I appreciate you sharing those experiences.
Yeah, it's good to know. At first I kind of thought, oh, well, how many times is that going to apply? But really, I mean, you said a medical practice, ambulatory surgery center. And I think, you know, COVID certainly has hit some of the, obviously, you know, non-essential things that people might otherwise be doing. So I wouldn't be surprised if we don't have an uptick already in those kinds of cases. So it's good to know.
Yeah, out of my caseload, 25% fall into that category. And
Yeah.
the patient care ombudsman has been raised in each of them.
So I think that we put the codes for the CLE into the chat, but I will also include it in the email when I send out the materials. And don't worry, you don't have to send me your email address. I've got it from when you registered, and I'll just send it to all registrants.
Leanne, do you want me to mention it real quick? So I have the Florida CLE number. I did put it in the chat, but it's 210-2685 N as in Nancy. So 210-2685 N.
And that's only for Florida. And then we have a separate code for the Puerto Rico.
With Puerto Rico, we had to go for another process. We have to submit some forms and evidence that everyone attended. In the chat room, I put one message to if you want CLE from Puerto Rico to send an email with a code that it was IWIRC pound 2021 to an address. We'll send an email with that information to my assistant so we can submit all the forms to the Supreme Court of Puerto Rico along with the evidence from this program.
Okay, perfect.
Receive credit.
Perfect. And I'll include that information as well when I send out the materials in case anybody missed that. Any final thoughts? Anyone, any final comments?
Well, I just would say thank you, ladies. You all were great. And also to all of our participants and attendees, thank you all very much. If you have any questions on which I can be helpful, I welcome you to reach out to me through email or my phone, or by, give me a call.
Yeah, and I'm sorry we didn't get to take questions, but it is 1:02, so it's time to stop. Thank you everyone for joining us, and thank you panelists. You did an amazing job. I really appreciate it.
Thank you.
Thank you.